Okay, okay, well, this happened in 1982, and it was about this case, Riley versus Hendrick Hudson School District, and it was the U.S. Supreme Court's first interpretation of what then they call it the Education of All Handicapped Children Act, which is now the idea that, I don't know which group went over that, but this case basically concerned a hearing impaired girl named Amy Riley. She was a student at Furnace Woods Schools in Hendrick Hudson Central School District, which is in Peaks Hill, New York. And Amy had a minimal residual hearing. She was an excellent lip reader. So administrators prepared for Amy's arrival by attending a course of sign language interpretation. At the end of the trial placement, it was determined that Amy should remain in kindergarten class with continuing having this FM transmitter. And an IEP was prepared for Amy during the fall of her first grade year, which provided that Amy should be educated in a regular classroom and should continue to use her FM device. And she'll receive instruction from a tutor for the deaf for 1 hour each day and from a speech therapist for 3 hours each week. The Rileys agreed with this, part of the IEP, but insisted that Amy also provide a qualified silent language interpreter in all her academic classes. So they actually had an interpreter placed in Amy's kindergarten class for a 2-week experimental period, but it was reported that she didn't even need it. So in this conclusion, it was reached that after consultation with the school district committee on the handicap, which had received expert evidence from Amy's parents on the importance of interpreter. When the request of an interpreter was denied, the Rileys demanded and received an administrative hearing. When this hearing went on, after receiving evidence from both sides, the hearing officer agreed with the administrator's determination that the interpreter was not necessary because Amy was achieving educational and academically and socially without this assistance. The examiner's decision was affirmed on appeal by the New York Commissioner of Education, and the Rileys then brought an action to the United States District Court for the Southern District of New York, claiming that the administrator's denial of the sign language interpreter constituted denial of free or public education, basically trying to just override them. But the holders in this Riley case have become the standard of analysis for every subsequent special education case arising in the federal and state courts.
All right, Daniel R. versus Board of Education.
For my classes, so don't break character. Okay, so Daniel was a 6-year-old boy who was identified for special education with moderate retardation. He was developmentally like a 2 or 3-year-old, so he was placed in a pre-K classroom for half of the day and a special ed classroom for the rest of the day. But the pre-K teacher said that he needed constant attention and she wasn't getting anything done with the rest of her class, so she decided that he needed to be in special education all day. And Daniel's parents were not happy with this because they wanted him in the regular classroom as much as possible. So they decided to take it to the courts, and they said that since he was receiving little to no educational benefit in the classroom, they agreed with the school. And then the case was taken to the district court, which also agreed with the school. Then they took it to the Fifth Circuit Court of Appeals, and the court said that there was a 2-pronged test, and the test asked the 2 questions. 1, can education in the regular classroom with the use of supplemental aids and services be achieved satisfactorily? And then if that's yes, if it's no, if it cannot, then have the school mainstream the child as much as possible. So they decided that the answer to the first question was no, that he wasn't going to be able to achieve academic success in the regular classroom. So they ended up agreeing with all of the prior decisions that he needed to remain in special education classes all day.
Court's adjourned.